There was a letter on my desk the morning of the sentencing. It was not from the defendant. It was from his daughter, a woman named Priya, 31 years old, who had driven 4 hours from Columbus to be in that courtroom. She had written it before she made the drive and mailed it to my chambers because she did not know what else to do with what she was feeling. There was one sentence I read 3 times before I put it down. She wrote, "My father came to this country with nothing, and he never asked anything of it except the chance to pay his own way. This is the first time the country has been asked to do something for him. I hope it will." That sentence sat with me through the whole morning. That is the case I want to tell you about. Subscribe before I go further. Cases like this one do not happen as often as they should, and they deserve to be documented and heard the same way the harder ones do. Subscribe so you are here when I get to the part that made me remember why I chose this work. The defendant's name was Ramesh Nair. He was 68 years old when he walked into my courtroom on February 14, 2023. He had lived in the United States for 37 years. He had worked as a machinist at a parts plant in western Ohio, a plant that had since closed, and he was now retired, living on Social Security and a small pension. He owned a 2-bedroom house in Dayton that he had paid off in full in 2019, which he mentioned not as a boast but as context. He mentioned it the way a person mentions something that cost them everything they had and that they are glad they did not let go of. He was a small man, thin. He wore a dark blue suit that was slightly too large for him and a tie that someone had clearly helped him choose. When he sat down at the defense table, he placed both hands flat on the surface in front of him and kept them there, very still. I notice hands in my courtroom. People who are frightened often grip the table or hide their hands in their lap. Ramesh Nair laid his open on the surface in front of him, as if he had nothing to hide and was not going to pretend otherwise. That told me something before a single word had been spoken. The complaint had been filed against Dr. Harold Stein, a 61-year-old dentist with a private practice on Wilmington Avenue in Dayton. Dr. Stein had been in practice for 22 years. He was not a cruel man. I want to be precise about that, because the simplest version of this story turns him into a villain, and I do not think that is accurate. He was a man who had developed certain habits over a long career, habits that had gone unchallenged long enough that he had stopped being aware of them. One of those habits is what brought him into my courtroom. What Dr. Stein did was charge Ramesh Nair $840 for a single-surface amalgam filling on October 6, 2022. The standard rate for that procedure in Dayton at that time, according to the Ohio Dental Association's published fee schedule, was between $90 and $160. Ramesh Nair did not have dental insurance. He had asked about the price before the appointment. He was told over the phone it would be around $150. He wrote that number down. He showed us the paper he had written it on. It said "Dentist, $150," in careful, precise handwriting with the date beside it. When the procedure was complete, he was handed a bill for $840. He asked about the difference. He was told by the billing coordinator that the phone quote was an estimate and the final charge reflected the full cost of the procedure. He asked to speak with Dr. Stein. He was told the doctor was with another patient. He sat in the waiting room for 40 minutes. Dr. Stein never came out. Ramesh Nair paid the bill because he did not know what else to do. He said later in testimony, "I thought maybe I had misunderstood something. I thought there might be a fee I was not aware of. I did not want to make a scene." He had brought exactly $160 to that appointment. He had to call his daughter for the rest. Priya drove from Columbus and sat in the parking lot while he paid. I want you to understand what that cost him. Not only the money, though the money was real, $690 more than he had been told, a significant portion of his monthly income. What it cost him was the specific dignity of a man who had always paid his own way, sitting in a parking lot at 67 years old, calling his daughter because someone had taken more than he had brought with him. 3 days later, he filed a complaint with the Ohio State Dental Board. The board referred it to the county prosecutor's office. That is how it came to me. Subscribe before I keep going. I made a choice in this case that I want to explain fully. Subscribe now, because the reason I made it is coming, and I want you to be here for the whole explanation. The case file that crossed my desk in January 2023 was straightforward on its surface. Consumer fraud, willful misrepresentation of service costs, Ohio Revised Code Section 1345.02, civil complaint, not criminal. The potential remedies included restitution, civil penalties up to $25,000 per violation, and injunctive relief, a court order requiring specific changes to business practices. That last tool was the one I was glad to have. A fine alone would not do what needed doing here. What needed doing required the court to reach into how this practice operated and require something different. Injunctive relief let me design something rather than just assign a number. I used my discretion to look beyond the single transaction. The investigator from the dental board had reviewed 18 months of billing records. The pattern was clear. Patients without insurance, particularly elderly patients and patients whose first language was not English, were consistently billed at rates that diverged sharply from quoted estimates. This was not random, it was structural. My discretion allowed me to factor that pattern into the remedy, to design a sentence that addressed not only the harm to Ramesh Nair, but the conditions that had made it possible. Dr. Stein entered the courtroom at 9 a.m. with his attorney. He sat at the respondent's table with the contained, slightly rigid posture of a man not accustomed to being on this side of any proceeding. He had been a person of standing in his community for a long time. Being here cost him something, and he knew it. He looked straight ahead at the bench. He did not look around the room. Ramesh Nair came in a few minutes later with Priya beside him. They walked slowly. He held her arm, not because he needed to physically, but because she had offered it and he had accepted. He looked around the room when he entered. He looked at the windows, at the seal above the bench, at his hands once, then up again. When he sat down, he placed his hands flat on the table, same as before. Priya sat directly behind him in the first row of the gallery, and she did not take her eyes off the back of his head for most of the morning. I watched her from the bench. She was paying attention the way only someone who loves a person pays attention, not to the procedure, not to me, but to the specific human being at the table in front of her. Subscribe. I have been building to something in this story, and it is not where you might think it is going. Subscribe and let me get there. The first turn happened during testimony from Dr. Stein's office manager, Carol Finch, who had worked for him for 11 years. She was not hostile to her employer. She was clearly loyal to him. But when she was asked directly whether the phone estimates given to uninsured patients were accurate representations of what those patients would be charged, she paused and then said, "We were instructed to give range estimates. The ranges we gave were not always ranges the final bills fell within." She said it carefully, in the tone of someone who had been sitting with a discomfort for a long time and was finally being given a room where she could put it down. I wrote that sentence in my notes. I wrote it not because I needed it, because I wanted it. That was the moment the case stopped being a file and became a room full of people trying to understand what had actually happened. That moment was not legally decisive on its own, but it told me something true about the shape of the harm. What happened to Ramesh Nair was not an accident. It was the outcome of a system, and people inside that system had known it was not right and had continued because no one was asking them to do otherwise. That is different from malice. It is also different from innocence. It is the specific kind of wrong that courts exist to address. The second turn came in the form of a document, a written statement from a patient advocacy organization in Montgomery County that worked with elderly immigrants navigating healthcare providers. They had submitted 12 affidavits from individuals who had experienced similar overcharging at Stein Family Dentistry over the previous 3 years. 3 of those individuals were in the gallery that morning. They had not been called to testify. They had simply come and sat together quietly in the back of the room. 12 people were willing to put their experience in writing. 3 of them drove to a courthouse on a Tuesday in February to be in the room where someone was finally looking at what had happened to them. I noticed them the moment I walked in. When that packet of affidavits was entered into the record, I watched Dr. Stein's attorney. He did not object. He looked at the packet, then at his client, and something passed between them that I have seen before. The specific look of a person realizing the scope of what they are accountable for is larger than what they had been defending against. That look matters. It does not exonerate, but it is different from a look that contains no recognition at all, and I was watching for the difference. Subscribe. Because if this case surprised me, and it did more than once, I think what comes next will do the same for you. Subscribe and stay with it. Dr. Stein's attorney argued for a reduced penalty, restitution limited to the Nair transaction, and voluntary practice reforms rather than court-ordered ones. He acknowledged directly, without being pressed, that the billing practices had been inconsistent and that estimates had not always been reliable. He said his client was committed to change. He said his client understood that what had happened to Mr. Nair and to others was wrong. He did not minimize it. That mattered to me. Acknowledgement from a defense attorney is not the same as acknowledgement from the defendant, but it is not nothing. Dr. Stein testified briefly. Near the end, he was asked whether he had been aware of the gap between quoted estimates and final bills. He was quiet for a moment. Then he said, "I knew the estimates were rough. I told myself it was the way billing worked and that patients understood that. I did not ask whether they understood it. I should have asked." He said it quietly. He said it the way a person says something that is both prepared and true. Those two things are not mutually exclusive. I wrote it down, not because I needed to remember it, because I wanted to. That sentence, "I should have asked," was the moment I knew exactly what I was going to do. There is a kitchen table in my memory I have not visited in a long time. My mother immigrated from Kerala when she was 24. My father came a year later. They settled in Cincinnati, and for the first 15 years they navigated every bill, every contract, every official document in a language that was not their first, and inside a system that was not built to explain itself to them. I was 9 years old when a contractor overcharged them for roof work on our house. I remember my father at the kitchen table with a yellow legal pad, doing the math again and again to confirm what he already knew. He knew. He sat there doing it again because he needed to be certain before he would say anything to anyone. Not uncertain about the numbers, uncertain about whether he was allowed to object, whether it was his place, whether anyone would believe him. He filed a complaint eventually. Nothing came of it. He filed it anyway. I think about that legal pad sometimes. I think about what it costs a person to lay numbers out that carefully when every signal around them says they are probably wrong. I had not thought about it in years. This case brought it back into the room with me. I have not told you the full sentence yet. I am about to. Subscribe before I do, because I want to explain every part of it, and the explanation matters as much as the ruling itself. Subscribe now. Before I read the sentence, the room held a specific kind of quiet. Not the tight silence of a room bracing for punishment. The particular quality of attention that settles over a space when people are waiting to find out whether something they hoped for is going to happen. Ramesh Nair had both hands flat on the table. Priya was at the edge of her seat. The three people from the gallery who had come with their affidavits were perfectly still. I had made this decision carefully. Mercy, to mean anything, has to be precise. Vague mercy is just hope. Precise mercy is a plan. I had a plan. I told Dr. Stein, "I am ordering you to pay restitution of $690 directly to Ramesh Nair within 30 days of today. This is not a fine. This is the return of money taken from him under terms he was never given the chance to understand or refuse. It belongs to him, and this court is giving it back. I am also ordering a civil penalty of $14,000, payable to the Montgomery County Consumer Protection Fund. This amount reflects the documented pattern across your patient population. Not only the harm to Mr. Nair, but the systematic overcharging of patients who were least likely to challenge what they were told. Within 90 days, you will implement a written, signed cost disclosure process at your practice. Every uninsured patient receives a written estimate before any procedure. That estimate will be within 10% of the final bill, or the difference is absorbed by the practice. You will submit compliance documentation to this court and to the Ohio Dental Board within 90 days and remain under dental board monitoring for 24 months. You will also, within 60 days, conduct one community clinic day for uninsured residents of Montgomery County in partnership with the County Health Department at no charge to patients. 1 day, 8 hours, full services. Finally, you will write a personal letter to each of the 12 individuals who submitted affidavits in this case, not a form letter, a personal letter reviewed and approved by plaintiff's counsel before sending that acknowledges specifically what happened and what you are doing about it. If you complete all requirements within 12 months of today, I will reduce the civil penalty by $3,000. That reduction is not a gift. It is my way of stating plainly that I believe you are capable of doing these things fully and genuinely, and that I think you understand why they matter. Then I spoke to him directly. Dr. Stein, what you did caused real harm. I am not going to soften that. Mr. Nair sat in a parking lot at 67 years old calling his daughter for money because your office charged him 5.5 times what he had been told to expect, and then made it impossible for him to raise the question with you. He came to this country and worked for 37 years and never asked for anything he did not earn. You took from him that morning something that was not only $690. You took the experience of being able to trust a transaction he had done his due diligence to understand. The people in this room see that. I want you to know it is seen. You said today that you should have asked whether patients understood the estimates. That sentence was the most important thing said in this courtroom. I have seen people come through here who could not say something like that even when everything depended on it. I believe you meant it. What the next 12 months look like will tell us whether that is true. Ramesh, what happened to you was wrong, and this court is correcting it. You filed that complaint when it would have been easier not to. You were not wrong to believe that the number you wrote on that piece of paper was the number that mattered. It was, and you were right to say so. Thank you for staying with this story. It is not the kind of story people usually tell about courtrooms. Subscribe if it is the kind of story you want more of. I have more to tell. When the hearing ended, I was still at the bench finishing my notes. I watched Ramesh Nair stand slowly and turn to Priya. She was already standing. He said something to her in Malayalam, I do not know what, and she laughed, not loudly. The small, specific laugh of someone who has been holding their breath for a long time and has just been given permission to let it go. I put the cap on my pen. It was an ordinary thing to do, the kind of thing I do at the end of every session. On that particular day, it felt different. It felt like a period at the end of a sentence that had taken a long time to complete. On April 3, 2023, 47 days after the sentence, Ramesh Nair received a check for $690 in the mail. It came with a handwritten note from Dr. Stein. Priya told me about it later through the plaintiff's attorney. She said her father read the note twice and put it in the drawer where he kept important papers. She did not tell me what the note said. I did not ask. He put it in the drawer with the important papers, and I have let that be enough. No appeal was filed. When the window closed, I noted it and sat with it for a moment. It was not a confession. It was not a concession. It was a decision to let the outcome stand, to accept the shape of what the court had built and to begin moving inside it rather than against it. There is something I have come to believe through this case that I did not fully believe before it. The people most likely to be overcharged, misled, or quietly exploited in ordinary transactions are often the same people least likely to say so, not because they do not know they have been wronged, but because they have learned through long experience to doubt whether anyone will take them seriously when they speak up. What this case required of me was to take the complaint seriously in exact proportion to what it deserved, no more, no less, and to do it without flinching at the fact that the person filing it was elderly and an immigrant, and not the kind of person who usually has a courtroom pay careful attention to a number he had written in his own handwriting before a dental appointment. What this case gave back to me, not as a judge but as a person, was the reminder that precision is itself a form of respect. To do the math. To check the math. To say out loud that the math matters. I had not forgotten that, but I had let it drift. This case returned it clearly. To anyone who has been where Ramesh Nair was, who has paid a bill that was wrong, who has sat at a kitchen table with numbers that did not add up and wondered whether anyone would believe you, I look for one thing from the bench above most others. I look for the piece of paper with the number written on it before the appointment, the date, the phone record, the careful, quiet work of a person who knew something was wrong and preserved the evidence before they even knew they would need it. That documentation is not just evidence in a legal proceeding, it is an act of self-respect, and I treat it as one every time it crosses my desk. Write the number down before you go. Date it. Keep it. You are not being difficult. You are being precise. There is a difference, and it matters in every room where decisions get made. To anyone who was asked to pursue accountability for someone who hurt them and was uncertain whether asking for a full accounting was the right thing to want, I will not tell you what to want. But I can tell you what I have seen from the bench when people pursue accountability through proper channels rather than through the desire for maximum consequence. I have seen people leave the courtroom with something they did not arrive with, not peace exactly and not satisfaction in the simple sense, something quieter than either of those. The specific and particular experience of having been heard by a system that does not always listen. I saw it on February 14, 2023, when a man stood slowly from a table and his daughter laughed. Subscribe. I'm about to tell you the last thing. Subscribe and hear it. On September 9, 2023, the Montgomery County Health Department posted a notice on their community board. Stein Family Dentistry was hosting a free clinic day for uninsured residents. Date, address, services, hours, 8 in the morning to 4 in the afternoon. I did not go. I did not need to. But I read that notice, and I thought about who was going to walk through that door, and I thought about what it means when a sentence becomes a door rather than a wall. That is the image I want to leave you with, not the courtroom, not the ruling. A notice on a community board, a door open, and someone walking through it who needed what was on the other side. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I'm asking. Subscribe and stay. The comments below this video are a place for people who understand that justice and humanity are not opposites. I would like to know what you think. I read what people write there, and I take it seriously, the same way I took a handwritten number on a piece of paper seriously, the same way I took a letter from a daughter seriously.